My name is William Messenger, and I'm the Legal Director of the National Right to Work Legal Defense Foundation. This video is intended to provide general information about a private sector employee's right not to be a member of a union in a forced unionism state that lacks a right to work law. For more detailed information, please review the Foundation's website or contact the Foundation to request free legal assistance. Under the National Labor Relations Act, employees have a legal right to not be a member of a union. Employees who are union members also have the right to resign their union membership at any time. And this is true even in a unionized workplace. Employees subject to a union's representation still have the freedom to choose not to be a member of that union. Unions and employers cannot compel any employee to be a union member. The closed shop has been unlawful for decades. However, if an employee works in a forced unionism state that lacks a right to work law, he or she can be compelled to pay some union fees as a condition of employment. The nation's right to work states have laws that prohibit employers and unions from compelling employees to pay any union dues or fees to keep their jobs. But the nation's other states and Washington, D.C. are so-called forced unionism jurisdictions that lack these important employee protections. However, employees cannot be compelled to be full union members, nor can employees be compelled to pay full union dues. Under the Foundation 1 Supreme Court decision in Beck, that most of the non-members can be required to pay in a forced unionism state to a union as a reduced union fee for union expenses germane to collective bargaining. Non-members cannot be required to pay for union political expenses, union organizing expenses, or other union expenses not germane to collective bargaining. Now, if an employee wants to become a non-member and exercise their rights under Beck to pay reduced union fees, an employee can do this by sending a letter to both the union and the employer. It is good practice for employees to send resignation and objection letters by certified and registered mail and to keep copies for their records. Sample resignation and objection letters can be found on the Foundation's website. Now, whether an employee chooses to be a union member or a non-member is their own personal decision. Employees who choose not to be union members are still subject to the union's exclusive representation and to all terms of the union's collective bargaining agreement. It is unlawful for either a union or an employer to discriminate against employees who choose to be non-members with respect to their wages or other terms and conditions of employment. However, unions can reserve internal union membership benefits only to union members. So if you want more information about an individual's right to be a non-member of a union in a forced unionism state, or want to request free legal assistance with exercising that right, you can do so on the Foundation's website or by calling 1-800-336-3600. Thank you.